Hello and welcome everyone. Welcome back to another one of the Lawdit podcasts. My name is Lora Krastiva. I'm a trainee solicitor here at the firm and I'm graced by the presence of Mr. Izaz Ali, one of the solicitors, solicitor advocate, I should say, here at the firm. And today we're going to be discussing constructive dismissal. So this is a part 2 episode of what we initially covered, which was unfair and wrongful dismissal. So now we're doing a part 2 with the final type. So Izaz, may I bring it over to you for you to give us a start on what is constructive dismissal?
Absolutely, yes. So hi, listeners. Constructive dismissal is really, it covers a situation where an employee argues and says, I've been forced to leave my job. I've been forced to resign due to the actions of my employer. And in my employer's actions have been such that they have fundamentally breached or changed the terms of my employment contract. And the sort of common grounds that we've seen in relation to that in employment tribunal forms are really reducing an employee's pay, changing their duties or location of work without their express agreement, or another one is creating a hostile work environment, i.e. employer and other managers in the employment scenario have been sort of ganging up against me, or have been sort of very scrutinizing what I do, how I go about doing my work, and others are getting an easy ride, that sort of thing. That's really where we are.
And so thank you for that. So how long do you need to have been working at your workplace in order to have a potential claim for a constructive dismissal?
2 years, yeah. So 2 years continuous employment. And it's worthwhile considering that it can be a situation where something that we've covered in the past, which relates to 2P, which is transfer of undertaking protection of employment. You could have worked with another firm and then there's been a merger or an acquisition that's taken place, and then your time with the other firm or the other company will also be taken into consideration for that 2-year calculation.
Mm-hmm. Okay, thank you. And just to just kind of add, if you are someone that's listening and you believe you may have been constructively dismissed, this is something that's in a lot of cases can be difficult to prove. So it's very important, and what we say to clients is to just gather as much evidence as possible if you are still employed, as Izaz already ran through. So, whether there's been a change to your contract, whether there's just been a series of events that have built up that have led you to the position of resigning and being therefore constructively dismissed. So although you are technically resigning, constructive dismissal is often seen to be the equivalent of unfair dismissal, which we ran through in part 1 of this podcast, as the employee has been essentially pushed out from their workplace as a result of their employer's actions, and this may lead the employee to be entitled to compensation and other damages.
Just flowing on from that, in terms of the overlap between what we discussed earlier in another podcast to do with unfair dismissal and wrongful dismissal, constructive dismissal is often, there's an overlap between constructive dismissal and the actual aspects of unfair dismissal. And we can explore that in further detail by way of example. But in essence, the employee's got to show that it was such a serious breach of contract on the part of the employer that they can justify their reason to resign. And a bit of a grey area or a problem area is when an employee raises a complaint but then carries on working, in which case he puts up with a continuing breach. And that goes to weaken that person's case a little. So it's, constructive dismissal is that serious that, look, I can't continue with this and I've got to leave immediately. So it's important for the employee to be able to show that when it came to the resignation, they resigned promptly without delay. So it's an important aspect of it. Employers, what can you do to protect yourself? Again, something we've mentioned before, practices, procedures, good employment contracts, so that you cover off everything and you have a transparent procedure to follow, so that if anyone was to raise anything, you're covering yourself off to say that we followed what we set out at the outset. So I think that's really, really important for people to follow in that regard. In terms of further protection, I think from an employee's perspective, it's important to log any complaints, any issues as and when they occur, and then to raise these with line managers and other staff, and then to keep really a log of everything. And then it's worthwhile running through that scenario with ourselves or a skilled employment lawyer, just to be sure that what you're proposing does fall under the grounds of a constructive dismissal and or the grounds of an unfair dismissal, so that you're clear on where you stand with things.
Thank you very much, Izaz. I trust that this was very useful to the listeners. There's a lot to cover in these sorts of areas when it comes to employment law and dismissals. So if you do have any further questions in relation to constructive dismissal, or even to part 1 where we did wrongful and unfair dismissals, please don't hesitate to get in touch with Lawdit, because we will be able to review where you stand and provide you with further guidance as to how you can proceed. So yes, thank you very much for listening today, and we'll be back again soon with another podcast. Thank you very much, Izaz.
Thank you.
Thank you. Bye.